Welcome to Beyond the Law.
Beyond Law Group's podcast that brings you unfiltered conversations
with our lawyers, clients and friends.
We'll be having frank discussions about our experiences in the legal sector,
Sharing our thoughts on current topics from a legal and a personal standpoint,
as well as offering our top tips for those pursuing a career in law.
Beyond the Law.
Beyond the Law.
Beyond the Law.
Hello and welcome to a Beyond the Law podcast. My name is Jason Stanley. I'm a solicitor and partner at McAlister Family Law, and I am delighted to be joined by my two guest speakers today, Russell Kaminski, a partner, and Lucy Cresswell, a solicitor, who formed the dynamic duo of the newly formed Vault, which I'm sure we'll talk about in a minute. But before we launch into that, I've invited you today to be guest speakers on this podcast. And in return, you've invited me to your launch party at the Ferrari Garage in Wilmslow. So I know who the real winner is in this scenario. But welcome and thank you for giving up your time. And ladies first, Lucy, if I don't, you don't mind, I'll ask you first. Vault, give us a bit of an overview. What is this about? It sounds very dynamic and interesting.
Yes.
What do you do?
So Vault is a new specialist practice under Beyond Law Group, where we are filling kind of the gap in the market of the firm to cover things like wills, trusts, inheritance tax and probate. So estate administration. When someone passes away, we deal with the estate of individuals.
Yep.
We do work for individuals and businesses, so we can do things like in collaboration with the corporate team, business succession and intergenerational wealth planning. But the main bread and butter of Vault is wills, trusts and probate, but we do weird and wonderful things as well.
Excellent, excellent. There's certainly a lot of overlap with what I specialise in. So unmarried couples, they don't have to be in a romantic relationship. They could be friends or colleagues or people who are just pooling their resources, and particularly buying property, which is crucial to that dynamic. Russ, people who buy houses need to be careful, don't they, when they're going to buy a house, because it can be tricky. It sounds really simple, but beneficial ownership needs a little bit of thought, does it not? Give the listeners a little bit of an overview of that.
Absolutely. So if unmarried couples were buying a property together, the starting point may be to buy it as joint tenants, which means that if something happened to one of them or they would sell the property, the proceeds would be split between them. If they were to own the property as tenants in common, which is another way of owning property, they can specify exactly how that property is split between the two. So they could set out specific shares, for example, or they could enter into a declaration of trust, which sets out how the beneficial ownership is held between the two.
Yeah, and I suspect if a conveyancer got an instruction and they knew the surnames were different, it'd be a bit of a starting point to say, you need to think about this because it's important. Joint doesn't necessarily mean joint, does it? But there's other tips. If you, as Vault employees, are advising people to buy houses, as you said, you might go a little bit further and think about future-proofing it as best you can with a will. And it's sensible, perhaps, to get your solicitor on board while you're going through that process and to think about that will, because it could go wrong, couldn't it?
Yeah, exactly. And if you own the property, as Russ said, as tenants in common, you will each have an identifiable share which will pass in accordance with your will because it won't pass by survivorship. So it happens a lot where people who aren't married want to benefit different people.
Yes.
Until they are married, they might do another will. But at that moment in time, it's really important for them to get their wills done. And it's also an introduction to the family team to do cohabitation agreements as well.
Massively, because there'd be some overlap in that regard. But if you didn't do a will, isn't it a world of pain? Isn't it tricky for those that you leave behind?
It is, yeah. Even if you have quite a vanilla family structure, it can end up, as I've dealt with on the other side of the probate world, very kind of messy and difficult to unravel.
Okay.
Your estate will be governed by the intestacy rules instead, so the government will actually decide how your estate is distributed.
Is there a pecking order? I think
There is.
They used to when I was at law school. That starts off with sort of family, and it goes all the way down to probably the king now, I think, if that's
Yeah,
right.
so the end one is the Duchy of Lancaster. So it's not ideal for most people, and that is when people spend thousands on the contentious side of things to make claims against estates. But the intestacy rules 99% of the time aren't what people intend to happen.
Yeah.
So by signing a will at a small expense, even if it's something simple, is worth doing.
Yeah, because investing in your lawyer, even though you're going through this very positive experience of buying a house together, getting expert advice from people like yourselves to then think about a will is a little bit of expenditure at the beginning process, but it's small fry really compared to the litigation costs they're going to have to think about and fund if there is a dispute, if there's no will or the documents don't align.
Absolutely. And it's not just thinking about the will and the declaration of trust, there's sort of a bigger picture planning opportunity here. So we will work with financial advisors to ensure that there is life insurance in place as well. So you can imagine an unmarried couple, relatively young, with a decent mortgage on a property.
Yeah.
If one of them passes away, we need to be thinking about who's going to carry on paying for that mortgage.
Yes.
Because suddenly it might become unaffordable. And if half the property then passes to the family instead of the surviving partner, there is a risk that that survivor is left with half a property but the full mortgage to pay off.
Yes.
So we will work with other advisors to ensure that there is that sort of collaborative piece
There's
of
a
work. that's
collaboration
done.
going on.
Exactly.
Yeah, absolutely. I think there's nothing like a separation for a couple to stress test what they think or understand, or as the case may not be, their financial affairs is there, because people go into this completely blind. I think there's a case that we were discussing the other day where it was quite tragic, wasn't it? And one of the most difficult ones you worked on, where something unforeseen happened, and boom, it was a car crash. Frankly, wasn't it?
Yeah.
Give. You don't have to disclose the details, but give us an overview of kind of an example.
Exactly that. So it was an unmarried couple, relatively young, sort of under the age of 35. They were due to get married within a few months after the person passed away. And had they been married, the estate would have passed under the intestacy rules to the surviving spouse.
Yeah.
However, they thought, that there was a low chance of them passing away in that small period of time. And so they didn't engage.
He was
with
an ultra
solicitors.
marathon runner or something
Yeah,
like very fit. You wouldn't
exactly.
notice. You
Correct.
wouldn't even think that this person had an underlying issue at all, would you?
Exactly that. And so we get a lot of people coming to us saying, we think we're too young to do our wills, and there's no such thing as being too young.
There isn't.
And whilst it's sort of a bit of a morbid topic to think about and discuss, once it's done, it's sorted, you've got peace of mind. It means that those that you leave behind are protected.
Massive.
You're not leaving them with a world of pain, not only grieving for your loss, but also making sure that they are financially secure and that there's no disputes later down the line as to what would happen to their estate.
Leaving pain.
Mm.
You know.
Exactly.
My daughter's a 1D. She was
Me too.
devastated. Oh, right, okay. But yeah, that's a classic example. It's in the public
It
eye,
is.
and look what happened there.
Yeah, so the rules of intestacy there, if Liam had made a will, depending on what he would have wanted to happen, his child bear he's basically going to inherit millions, over £20 million at the age of 18. There's no options to do a deed of variation, which is where you can retrospectively change what's happened in a will. And he can't consent to doing one of those under intestacy because he's under 18. So the provisions there are that he's going to inherit this money, which is quite scary. Mm-hmm. So the will would have just protected that and put trust structures in place, which we can advise on to make sure that the money is drip fed to him appropriately. And the other side of things is appointing executors. So it's not just who benefits, but it's also who deals with your finances.
That's a careful consideration to somebody really trustworthy and sensible who's going to understand the dynamic of the family, I guess. You have to really think about that, do you not?
Exactly, yes. Because if they aren't married, most likely they would want each other to act. But if not, there's another rule of list from the government who does what. So it's just out of your control. So it's those unmarried couples really need to think about getting the will in order, and we can do an expectation of marriage clause in the will to make sure that the marriage doesn't revoke the will. So you don't need to hold off doing it until you've gone down the aisle.
What depresses me, he's was a multi-millionaire, and it's not a cost thing for him, and he just didn't have the mindset.
It's a burden.
And our job is to educate the public out there to say, think carefully. This is probably your home, the most expensive asset you're going to ever have. A mortgage, your future. In the case of death, it's so critical. Why don't you invest in getting your house in order, so to speak?
Yeah,
It's
I can't believe when they didn't win X Factor that they didn't get told to do their wills. I just think like someone with level of wealth, even if you've got £10 or 10 million, you need a will.
If only Volt was knocking around at the time.
I know. I just messaged Simon McAlister.
Well, here's an anecdote. I took a new instruction last week on Thursday, so I'm going to put it to you, in which there's an unmarried couple in their 50s. They jointly own their house, joint tenants, and they have a rental, and it's joint tenants, and they're doing a remortgage on the rental property, and the mortgage lender has appointed a broker who said that the woman needs independent legal advice because she's going to give up and assign her beneficial interest and a legal interest in the rental to him. Right. And they are nervous about that, and they want her to get advice from somebody like me to say, why would you do that? Do you know what you're doing? Mm. And when I spoke to her, she said, can you just sign something on a piece of paper? And I went, hang on, I want to just get a bit more detail here. She has an adult child from another relationship. He has 2 adult children from another relationship, so it's a blended family for a start. And I said to her, if you do this, you're signing the rental completely to him. If you predecease him, so you die first, that house automatically reverts to him. Your daughter's getting the sum zero of nothing. And she said, oh, I didn't think of that. And I said, what did you have in your mind? And she said, oh, I just thought my daughter would be all right. Well, can your partner live in the house? When does it kick in? And that's just a basic conversation. And she was not cross and agitated, but she really wanted me to just sign something, and I wouldn't do it.
Yeah, and I think a lot of people, they don't sort of want to think about the worst case scenario. And unfortunately, it's our job to think about what could go wrong. Absolutely. And we've seen it go wrong, and therefore we know the things that we need to look out for, and where asset protection structures can be put in place,
yes,
and how best to do that. And I think it's our job to sort of push and challenge people's perceptions.
Yeah, absolutely.
And almost play devil's advocate a little bit.
Because it's not etched in stone. You can always revise and refine it in a cohabitation agreement or a prenuptial agreement, which is something I do quite a lot of. We have a review clause that permits something massive on the horizon, like a child being born or an inheritance or something, so you can tailor it to how you want it. As long as there's consent and you're on the same page, you're not stuck with it for 20-odd years, are you?
No.
It's a fluid thing.
Correct. And a lot of our clients opt for something called a discretionary trust will.
Okay.
So whilst the will itself will remain the same, there's a letter of wishes that we produce that can change over time.
Right.
And that's a document that's addressed to the trustees, and it will say things like, give my child a deposit for a house, but don't necessarily buy them a mansion, and things like that. Yeah. So as they see their children grow up, they can get in touch with us and change that letter of wishes to adapt to the new circumstances. So it's a really flexible way of making sure that children are protected.
Just to pick up on something you said before, which I was rather intrigued about for the listeners. You said if, say, a couple were engaged to marry, you might do a will in anticipation of that marriage.
Yeah.
How does that work then? So is it a sort of leading to the marriage and then you do a new one after you're married?
So marriage revokes a will, so we can put a clause in the will, say, because people now enjoy their engagement, they don't like to rush and get married. So we can do your will on the date of engagement or whenever and put a clause in the will to say that the marriage should not revoke the will. So having that clause protects and bulletproofs the will from when you are married, so it would still stay the same. But probably quite a lot of times without that clause, people probably think they have wills in place that they don't.
Gotcha.
So it's a really good clause that we can use and put in wills.
And as a sort of broad stat, do you find that there's quite a lot of intestacy stuff, or is it becoming less prevalent? Are people sort of wising up a bit more?
I think it's more and more common. I think the latest statistics were something like almost 60% of people don't have a will.
Wow, over 50%.
Correct, yeah. And I think that would be even higher for those under the age of 40, for example.
Yes.
And they're the people that will have young children, and therefore if something happens to them, they're even more exposed. We've not touched on it yet, but also guardianship provisions is a really important thing to include in wills.
Yeah.
And that's probably the most pressing reason someone would come to us if they're quite young, on the basis they've had a child and they want to ensure that someone is appointed in the event that they were to pass away before they're 18.
And just on that guardian point, if, say, there was a couple and, say, the woman appointed a guardian in the event of her death, that she didn't want the father to look after the child, she wanted her sister, say, would you ever get that kind of instruction, and how binding is that?
Yeah, so really good question. The starting point is that the other biological parent has parental responsibility, so they would automatically take guardianship of that child. So it's really on second death that the guardianship provision comes into play.
Gotcha. Unless
there is sort of a court order saying that actually the other biological parent isn't currently the one that has guardianship of that child.
Gotcha. Well, I am grateful to you for giving up your time. Is it your first podcast?
This is, yeah.
Thank you for having us.
Hopefully it's
Relatively painless.
painless.
Yeah.
And thank you again. It's really been invaluable. I can't thank you enough because, as I say, much of what you do complements the kind of work I do. And I feel like I'm on a campaign to try and educate the masses out there, because the unmarried demographic is on the rise. Less people are getting married. They're forging relationships, buying property, having babies. And I think we are going to consistently see that escalation. So again, thank you very much.
Thank you.
Thank you for having us.
This has been a Beyond the Law podcast. Thank you for listening and tuning in. Be sure to look out for other episodes in the future.
Thank you for listening to this episode of Beyond the Law.
To keep up to date with all things Beyond, follow us on our socials at Beyond Law Group.
You can tune into our next episode wherever you find your podcasts.